So today we're starting a topic which is called the pillars of the Jewish community, trying to understand some of the Jewish institutions in communal life. Before we begin, I just want to, as words of introduction, and we'll get to the sponsorship in a moment, just as words of introduction to this entire series, I think is important to appreciate as follows. The Torah tells us that a number of years ago, Moshe Rabbeinu was looking for some help. And so in Parshas Ba'aloscha, he asks for help. And Hashem suggests he finds 70 Zakanim, 70 elders. He does so, and not all of them can join the party. So there's Eldad and Meidad, these fellows who don't come forth, but they are misnabim b'machaneh. We don't know what exactly the details are, but they are oversharing. It sounds like they're giving prophecy in the camp of Israel. So Yoshua ben Nun is very concerned about this. So he turns to Moshe and he says, Adoni Moshe kila'im. Moshe Rabbeinu, and what this usually sounds to be is lock them up. That's what it's usually translated as to me. Rashi says that it means hatel alehem tzorchet zibur. It says, give them a community job, ve'im kalim alehem, and they'll stop talking. Right? And it's a really important point to appreciate is that so many times our opinions are formulated about communal institutions from a lack of knowledge. And so we have so much to say around the Shabbos table, we just don't know how much is involved in those communal institutions. Then for anybody who's had the opportunity of serving in some form or fashion as a president, as an officer, as an executive on a non-for-profit organization, on a communal organization, suddenly they realize the complexities, the difficulty of running a communal institution. And so I wanted to take this opportunity to learn a little more about, to become more educated. We can't all become executives, we can't all become board members or chair people on non-for-profit, so I encourage people to, because it's very educational. It's incredible what one can do for the Jewish community. But to take a little bit of a look behind the scenes, to appreciate what it means to be involved in a communal institution. And I would argue that the people who are running Jewish organizations are superstars because they have to do so much more than the equivalents in the for-profit sector. In the for-profit sector, the job of one executive in a non-for-profit organization would be at least 4 different jobs for a person in the for-profit sector. But they have to do so much to make it work under incredible public scrutiny and unfair complaints. And therefore, it's important for us to take a look behind the scenes and see, wait a second, what makes these institutions, wherever we go, whether it's Spain, France, Barcelona, New York, wherever it is in the world that we go, there are Jewish institutions, and I'd like to gain an appreciation of them throughout the ages. Today, I want to take a moment to thank our sponsors today. I want to thank Ed and Sandy Clark, who are sponsoring today for the Refuah Shlomo of Tzu Cholot. Be'ezrat Hashem, our learning, our discussion, and our continued discussion should be in the merit of their Refuah. And that is for the Rivka Devora Bas Alta Chaya Zissel and Malta Raza Bas Sarah Fega, whose refuah should be Bekarov, Be'ezras Hashem, refuah Shlema Bekarov. So what we're going to do, we have the opportunity today of starting with one of the formative institutions in the Jewish world, and that is the Beis. Wherever you go across the Jewish world, you're in a community, you have to be within proximity of some Beis. And throughout the course of Jewish history, this has been the case. And we are very fortunate in our context in New York to be actually very close to the Beis Din of America, which, and full disclosure, I had the opportunity of interning at many years ago under Rabbi Weissmann, and it is really a zechus, a merit that we can welcome back to our shul, Rabbi Weissmann, who is the Menahel, the director of the Beis Din of America. Rabbi Weissmann has received his rabbinic ordination from Reitz Yeshiva University, where he also not only completed regular smicha, which is called Yore in ritual matters, but also in Yadin Yadin, in legal jurisprudence as well, from YU. He is also a graduate of Columbia Law School. He was a Harlan Fiske, is that the correct pronunciation? Yes. Fisk Stone Scholar. He is also, before being involved in the Beis Din of America, served as an attorney in many prominent law firms, including, and let me see if I can get the pronunciation right, Debevoise and Plimpton, LLP, and besides managing the Beis Din as well, which is a Herculean job, he also serves as a dayan on the Beis Din in many of the panels and deals with many complicated issues. He is an adjunct professor of the Sassoon School of Business and writes many articles relating to Jewish and secular law, especially as it relates to rabbinic court arbitration. It's really a pleasure to welcome Rabbi Weissmann to our shul. It is a zchus for us as a community. Thank you, Rabbi Weissmann.
Okay, thank you so much for having me.
This is going to be, Be'ezras Hashem, a wonderful conversation, and we're going to do this in the form of a conversation because there's so many different things that we need to explore. So I just wanted to just start off as just, I guess, an underhand rule, which is just to understand, when did Beis Din become a thing? Like when in Jewish history did Beis Din start becoming a issue, a communal issue of importance?
It probably precedes any other communal institution because it's Yisro in the Midbar that really comes up with the idea of a Beis Din. Moshe's figuring everything out himself. He's a solo practitioner. All the disputes are coming to him. And Yisro observes that this is a little much for one person, and he's the one who says to Moshe, you should really set up an institution like the Beis Din to handle disputes. You should be appointing people below you. You should, he was the first one who really, I guess, not just in Beis Din, but he was the one who first one came up with this idea of a corporate structure. And so the Beis Din was the first experiment in that, and that's where it starts. Obviously, it takes on some different formats and different forms as the Jews attain sovereignty and as there's a Sanhedrin. So then there's a more formalized structure in the form of a Sanhedrin, and the Sanhedrin is just one part of the structure. There are local courts of 23 members, local courts of 3 members. All of Gemara Sanhedrin kind of talks about all these different permutations. But throughout Jewish history, we had Jewish courts, and like many aspects of Jewish life, it continued even when the Jews were not in charge in terms of having a commonwealth, in terms of having sovereignty. There were Jewish communities, and the Torah understands that halacha pertains and speaks to not only ritual aspects of our lives, but all aspects of our lives, including monetary issues that need to be resolved. And so throughout Jewish history, even in the diaspora, we had Batei Din. There's numerous references throughout the Sfarim, throughout the rabbinic treatment of all sorts of monetary laws about how a Beis Din would handle it, and how Batei Din handled it throughout the Galus. And then in modern times, I would say that the institution of Beis Din took a nosedive in terms of popularity, in terms of its role and its centrality in Jewish life. In Europe, that Beis Din was a central institution, and that's probably because the rabbinic leadership and the structure of the community was much more centralized. There was a known, within each shtetl, within each community, or within each city even, there was a kind of a known hierarchy. You'd have the rabbi, the rav of the community, and you'd have a Beis Din, you'd have an Av Beis Din, and it was known that if you were within Vilna, you'd go to the Vilna Beis Din. If you were within Brisk, you'd go to the Beis Din in Brisk. In America, that kind of changed, and there was, as we know, much less of an autonomous and much less of a centralized community structure. And I would say Beis Din took a nosedive in terms of popularity. Our particular Beis Din was started by the Rabbinical Council of America in 1960. And it was started because the community realized that there was a need for a Beis Din that would service the English-speaking population. Back then there were Batei Din, but they were mostly serving the old-school Yiddish population. And the American rabbinate saw the need for a organized and more modern, so to speak, Beis Din that would serve that population. But for the first 40 years, I would say, of the existence of the Beis Din of America, it focused really on what we think of as necessities. And specifically that means gittin, right? You can't really function as a Jewish community without people that would be, or a Beis Din that would oversee Jewish divorce in terms of the formal issuance of a get. Not handling any other aspects of a divorce, not handling, for the most part, monetary disputes. The Beis Din of America really focused on gittin, I would say, for most of its 40 years. There were a few chalitzas, there were other kind of necessities that came up. But the issue of dispute resolution, which we're going to talk about a lot, I think, a lot more than gittin perhaps this morning, was something that was viewed kind of as a luxury and not a necessity within Jewish life. People resolved their disputes among themselves, or people went to court. And we'll talk about why that's not a good status quo. But that's really how it stood for about 40 years. And then in the mid-1990s, the Beis Din of America underwent a restructuring. And it was mostly at the initiation of the Orthodox Caucus, which was a movement or an organization that started back then that was addressed to other problems, but among them the Aguna problem. And the communal leadership saw the need for a responsible Beis Din that could responsibly handle complex issues, including contested gittin. This was around the same time that Rabbi Mordechai Willig was developing his prenup, which we'll also talk a little bit about, which was another attempt to address the Aguna problem. And communal leaders, including lawyers, among them Shelley Rudolph, who was the president of the OU, saw the need for a professionalized Beis Din that could bring to bear not only halakhic expertise, but also secular law familiarity and expertise. And that's how kind of the modern day Beis Din of America got started in the mid-1990s. And a lot of what we'll be talking about this morning is the manifestation of that dream and that idea over the last 25 years. So I got a little past the original question, but that's kind of my history.
Yeah, that's incredible, because actually I just came back from South Africa, and it's just, it is actually really refreshing where there's one centralized Beis Din.
Yeah.
And it's still a community which is small enough where everything goes to that Beis Din. That Beis Din governs the entire community, so that it's a breath of fresh air as opposed to, like, as you're describing here, where it's a lot more complex, so people have choice, and that choice unfortunately leads to complexity. As well. But just on a personal note, how did you personally get involved? And you were working in law firms. How did that turn into becoming involved in one of the most prestigious B'atei Dinim in America? How did that work?
So my connection with the Beis Din of America actually predates my current job. When I was in the smicha program, one of the requirements of the smicha program is shimush. So people who are in the smicha program anticipating going into Rabbanis, they'll get a job as a rabbinic intern. If you're going into chinuch, you'll get a job teaching as an assistant teacher or something like that. I myself didn't have any ambition to go into communal life. I was planning on doing smicha and then doing law school and becoming a lawyer and practicing law. And so I wasn't sure exactly what I should do as my shimush, but I heard about this opportunity at the Beis Din of America. Rabbi Yonah Rees, who's my predecessor, was at the time the menahel of the Beis Din of America, and some upperclassmen that I knew, meaning people ahead of me in the smicha program who were also going on the law school path, had interned at the Beis Din of America and said it was a good experience. And so I applied for that job as an intern at the Beis Din of America, and that's how I did my rabbinic shimush. And that was a great experience. I saw the inside of the Beis Din of America. I saw what a professional institution it was and what a unique institution it was. And that was it. I then finished my smicha, I finished my law degree, and I practiced in commercial real estate law for 7 years. And that was good. It was enjoyable. It was interesting. It paid the bills. But I still had a hankering for something a little more fulfilling. And at the time, I heard that Rabbi Yonah Rees was hired as the new dean of REITS, of the Rabbinical Seminary at Yeshiva University. And that kind of piqued my interest that maybe they're looking for replacements. I reached out to Rabbi Willig, who I knew I was a Talmud of Rabbi Willig, and he said, sure, apply for the job. I was extremely underqualified for the job because I had smicha, but it wasn't like I was the top guy in the Beis Medrash. I hadn't gone into Avodas HaKodesh. I had kind of gone on the law path, and it wasn't like I didn't have Yad Yadin. I didn't have any kind of rabbinical training in the way of what would be helpful for leading a Beis Din. But I figured, why not? You can't let an opportunity like that pass. And so I interviewed for the job, and to my extreme excitement and way that really changed the course of my life, at least professionally, I was asked to join the Beis Din, and I was hired in 2008 as the menahel of the Beis Din, and it's been a fascinating ride, fascinating journey ever since then.
Incredible, just incredible. I've been in the office and seen things on a daily basis just to see how much is going on in that small office, and it's astounding.
Yeah, when you were there, it was before we did our renovation. We did a renovation about a year and a half ago, so you have to come back. It was not a beautiful office, if you remember.
But there was a lot going on within those walls. There'd be people waiting, and you could have people in the antechamber waiting for a get, and then somebody getting Jewish status affirmed, and then a court case was being planned. There was so much going on in just a few rooms. But let's start at the beginning, because I think a lot of us sort of hear about Beis Din from the outside, and we don't really know. We just, unfortunately, there's sometimes a lot of negative associations, because we hear sometimes from friends what experiences that they've had, and we put all Beis Dins in the same sort of in the same car. I just wanted to let's go through step by step. So when is a Beis Din supposed to be engaged? Like at what point in time? When it's like today, commonly, when would a Beis Din be called upon to be involved in communal life?
Well, let's take a step back and kind of talk about the different spheres that we operate in, what the different services that we offer. I generally tell people we operate in 3 areas. One is matrimonial issues, where we are involved in the get, and that's a simple process. The get is an hour, simple not in the sense that you should try it at home, simple in the sense that it's an hour-long process. We schedule an appointment, we have a sofer, we have edim, the get is written, it's a 12-line long document that includes the names of the parties, and so the process, starts with us asking questions about the names of the husband, names of the wife. The husband and wife both read from a script to confirm that they're authorizing the get of their own free will. They'll authorize the get to be written and signed. It's written and signed. The whole thing takes an hour, and the get is finalized. That's how you dissolve a marriage under Jewish law. So that's one thing that we do. That's pretty routine. The second area in which we practice is dispute resolution, which is probably the biggest and most time-consuming and it takes up most of our energy. That ranges from disputes relating to businesses, partnership dissolutions, landlord-tenant disputes, employment disputes, the whole range of disputes that people might have. And that takes place in the form of arbitration, either where the parties are signing a binding arbitration agreement, agreeing to abide by the decision of the Beis Din, and then it goes to arbitration, to a din Torah, where we actually have 3 dayanim sit in the courtroom, and we adjudicate the case just like any court that you'd see on TV or in a courtroom. Sometimes we'll do it through arbitration. Sometimes we do it through mediation, which is a process where we sit around the table and we try to bring about a settlement through discussion, through negotiation, and through settlement talks. So either through arbitration or mediation, we're doing dispute resolution, ranging from, as I started to say before, business disputes to matrimonial disputes. The first category was the get, the formal get, but when people get divorced, there are all sorts of disputes that need to be resolved, custody issues, financial issues, and so we'll often mediate or arbitrate financial issues and custody issues relating to divorce. And then the third area in which we're involved is a hodgepodge of halachic decision-making. Most prominently for a Beis Din in the realm of personal status. If a person needs confirmation of their Jewish status, let's say, for example, they're getting married and there's questions about their yichus, they'll come to us and we'll work through that and we'll issue a decision. If a person's getting married in Israel, they need a formal declaration of a Beis Din that they're Jewish, and we'll issue a certificate for that. Sometimes there are mamzerus questions that come up, all sorts of other kind of personal status issues. That's the third area in which we're involved. And then the other thing I forgot to mention in the first area is disputed get situations, aguna situations. We can talk a little bit more about that. So you asked when would a Beis Din be engaged, and the answer is all of the above. In any of those situations, people will open a file with us. They'll go on our website and open a file, and we'll either issue a determination on personal status, or we'll have a full-blown din Torah on a dispute, we'll have a mediation on a dispute, or we'll do a get, depending on what it is that they need.
So let's dive into the middle category there for a second, because it seems that is a lot of time is taken on dispute resolution. So let's say there's a dispute in the Jewish community, and one party wants to figure this out. They want to get this done right, and so you said they open up a file. What's the next step? So like, what happens when this file is opened? How does that process work? How long does would that take for a person to go walk through this process?
Yeah, so the process, we refer to it as the hazmana process, which means the process of summoning a person to Beis Din. The background to this is that if you look in Shulchan Aruch, there are kind of 2 setups for a Beis Din in a community. On the one hand, if you have a centralized structure where there is a recognized Beis Din and is the recognized Beis Din in the community, that might be the case in a place like South Africa or elsewhere, then it's kind of a lot more streamlined. If someone has a dispute, that's the place they go to. That's a Bezdin HaKavua, and that's the place you go to, and there's not really a lot to talk about. In the United States, that's clearly not the case. Moshe Feinstein, early on in his tshuvas, says, just to clear the air, the United States is a place where there is no Bezdin Kavua. That's true probably in virtually every community in the United States, although in some communities there's a little more of a structure. Maybe Baltimore is a little more of a structure. But clearly in the United States, there's no Bezdin Kavua. Anyone can open up their own Bezdin by just, hanging out what is it called?
Shingle.
There's no Bezdin Kavua, which means that if an individual has a claim and wants to bring a case to a Bezdin, the way they start the process is by opening up a file in the Bezdin of their choice. Let's say, for example, they're comfortable with the Bezdin of America. They'll open up a file on our website, fill in the information about the plaintiff, about the defendant, include a description of the claim, because that's important, because we attach that to what we call the hazmana. The next step is that we send a hazmana, which is a summons. It's really a letter, an invitation that says we've been contacted by individual A, plaintiff, who has brought to our attention a dispute between him and you, or between her and you, and the dispute is summarized on the attached sheet, on the claim letter that the plaintiff has provided, and you have 14 days to respond to let us know how you'd like to proceed. We reference our rules and procedures, which lay out the options of how they can respond. The recipient has the option of responding by saying, okay, I'm prepared to submit my case to the Bezdin of America, and in that case, we will send out a draft arbitration agreement for them to look at and sign. And then once the arbitration agreement is signed, we'll move ahead to scheduling a hearing. Because we're not the Bezdin Kavua, however, the defendant has the option of responding by saying, I'm prepared to go to Bezdin, but I don't want to go to this Bezdin. I'm prepared to go to a different Bezdin. And then they could proffer the name of a different Bezdin. And that's when things can get a little sticky, because if the plaintiff wants to go to the Bezdin of America, and the defendant wants to go to, let's say, Machon La'ira in Monsey, which is a Hasidic Bezdin in Monsey, so then there's a stalemate. In theory, they could both kind of compromise. One could agree to go to Bezdin America, or the other would agree to go to Machon La'ira. But if there is that stalemate, then what's supposed to happen is the establishment of a Zabla. Zabla is an acronym in Hebrew for Ze Borer Lo Echad, V'Ze Borer Lo Echad, meaning it's a Mishnah in Sanhedrin. Each one chooses a single arbitrator, a single dayan, and then the two dayanim choose a third dayan, and then that ad hoc bezdin, that blended bezdin, serves as the panel to hear the case. So that's a Zabla. We could talk a little bit about the pitfalls of Zablas and why they're good or why they're bad, but be it as it may, that's the way the Mishnah says you should handle it in a situation where you have this stalemate over bezdin. And then, of course, a person could respond to a hazmana by either not responding or saying, go fly a kite, I'm not coming to Bezdin, refusing to come to Bezdin. In that situation, we'll follow up with a second hazmana, with a third hazmana, and ultimately we could warn of the issuance of a seiruv, and then ultimately issue a seiruv. A seiruv is a document of contempt that says that this individual is not complying with his obligations under Jewish law of coming to Bezdin, and as a result, the community should put pressure on them to do the right thing and to come to Bezdin. And those are really kind of the three ways that the hazmana process could play out.
So let's talk about a compliant responder, right? So let's say somebody's been summoned to the Beis, and he says, she says, I do want to go through the Beis of America. So then how, are there specific dayanim in the Beis of America? Is it based on the case? How does that work? Just let's say they're going with the Beis of America.
Yeah, so if they're signing the arbitration, once they've signed the arbitration agreement with the Beis of America, we internally will assign the panel, we'll assign the dayanim. We have a roster of about 10 active dayanim, 12 active dayanim, and some are more active than others, and we'll staff the case based on, we try to kind of have a mix of expertise on the case. On every case at the Bezdin of America, this is unique about the Bezdin of America, there's at least one attorney on the panel. We think that's very important, especially for complex commercial cases. You can't really understand the halacha unless you understand the metzias, unless you understand the facts and the circumstances of the case. and unless you understand the business environment in which the parties are operating. And so it's important to have someone with that expertise, with that knowledge on the panel, to have that knowledge indigenous in the panel. Like, that's very, very important. I find that often it's the attorney on the panel. The attorneys need not be only an attorney. Oftentimes it's someone who has dual expertise. So he's a rabbi and an attorney. But often that person is kind of the most informed of the panel, is the lead of the panel, and really sets the tone for how the Din Torah is going to go. So we staff it based on a mixture of expertise. We'll put on people who have very deep Torah knowledge, deep secular knowledge, and that's the panel that hears the case. That's the panel that hears the case in the Beis of America.
Phenomenal. So then, and let's go the other part. Let's say a person doesn't want to. Say they don't want to go to the Beis of America, whether they're playing games or they just don't. This is not their base, not their community. However it goes. So they want to go to another base, and we get to that stalemate that you described. So let's say now there's a stalemate, and there's this notion called the zabla, this ad hoc based in. Full disclosure, I've been taken to based in just because of serving the community. Thank God. For trying to help the community. I was sued by multiple people in this community. And so, not this particular community, just in the larger Five Towns community, trying to help the community gets you sued by the community. Thank you to Kashrus. So I've been through this process myself, and it's a very painful process too. So, two questions. Number one is do you research the claim before issuing a hazmana? Meaning, let's say somebody has a preposterous claim, a ridiculous claim, and they fill out a form. Do you just pro forma go forward and invite the defendant, or do you exercise discretion in trying to figure out, is this actually a claim which holds water?
We don't do any external investigation. We don't poke around on the internet and kind of figure out whether it's a meritorious claim. But we require the claim to be coherent and to state a claim, essentially, on its face. Meaning, the claim letter that the plaintiff submits to the Beis of America, we'll look at that, and we'll say, does this make sense? If the claim is completely outlandish, or, we kind of do, for the lawyers in the room, we use a summary judgment standard. If you assumed all facts as alleged to be true in this claim letter, would that result in a meritorious claim? If the answer to that is no, then we're wasting our time. We're not going to send out hazmana and harass someone for a claim that just doesn't even get off the ground. So we'll reject a claim letter where it doesn't meet that summary judgment standard. We'll also reject the claim letter, or we'll tell them to try again if it's unreasonably simplistic in its presentation for a claim that is more sophisticated. Meaning, if you say in your claim letter in one line, this guy owes me $1 million because he stole my opportunity as a real estate broker, that's not a well-formulated claim. We need a little more meat before we're going to send out a hazmana. We need you to kind of plead out a basic fact. On the other hand, if it's a much smaller claim, then one sentence might suffice. It's a reasonableness standard that we apply, and the idea is to weed out nuisance claims and really only to harass people, so to speak, or bother people with a hazmana if there's something that on its face looks like a real claim.
So that's the first. So now let's assume that somebody gets to the hazmana, they're not going. We get to the stalemate, and I interrupted myself. But let's say we were trying to get and they created a zabla. So just from my experience, so the zabla is really like a circus, unfortunately, in the world, because it's already navigating and negotiating to get the person they want who's going to say the thing they want, and it seems, and just from my personal experience, it's really not a very pleasant or transparent process. There's zabla, which unfortunately seems to be the way that things work. So how does the Beis of America handle that? When do you feel that you have this is a responsible route that you're allowing to happen?
Yeah, so I agree with you. I don't like zablas. I think zablas are messy. It's a hard thing to say because the Mishnah itself, the Gemara itself, kind of recommends the zabla. And if you read the Rishonim, they all talk it up. You read the Rashi right there in the Gemara in Sanhedrin. he says that Zabla is great because by virtue of the fact that each litigant has a dog in the fight, has one arbitrator that's kind of looking out for his interests, and then a third neutral, you end up with I think his language is adin yotzei emes, that as a result of this like beautiful structure where everyone's represented on the panel, you end up with a really good outcome. Unfortunately, that assumes the good faith participation of the three dayanim as neutrals. And all too often, I think, nowadays, Zablas are structured and actually function in a way that the party-appointed arbitrator, the dayan chosen by each party, kind of acts as an advocate for the party, more so than just someone looking out for the interests of the party. And that could be problematic. We have a rule at the Beis Din of America, when there's this stalemate, and we're in charge of the Hazmana process, we won't issue a seder if you are, in good faith, naming another Beis Din and participating in that process, naming a dayan for a zabla. Our requirement is that you name someone who is not a towing, which kind of is a whole other conversation. In the industry of Batei Din nowadays, there's a position called a towing, a person whose job it is to be a rabbinic advocate, kind of like a lawyer. A lawyer is a secular law advocate, and so there are people out there who hold themselves out as toanim, as rabbinic advocates. Generally speaking, the Beis Din of America doesn't allow toanim to represent parties at the Beis Din of America, and the reason is toanim are not licensed.
Why?
The reason is because toanim are not licensed, and if you can imagine, if there are any lawyers in the room, lawyers need to be licensed to practice law. They need to abide by a code of professional responsibility. And that's necessary because a lawyer's job, on the one hand, is to fight vigorously for their client. But at the same time, a lawyer is an officer of the court, and a lawyer is supposed to uphold and not abandon, not violate certain ethical standards. And for all the lawyers' jokes that are out there, the truth is lawyers are a respected profession, and they bring about their participation in the dispute resolution process in an organized way is a good thing. Lawyers actually add something to dispute resolution and to the court process because they have to abide by a system of ethical standards. And if they don't, there's consequences. If a lawyer breaks a rule of ethical responsibility, he can get disbarred, he can get sanctioned. Things can happen if you're a lawyer. If you're a towing and you break ethical standards, you don't get disbarred because there's no such thing as the towing bar. You just get more clients because you've established for yourself a reputation as a pit bull and a person who's really going to advocate for his clients. And so therefore there's kind of a race to the bottom, and unfortunately the towing industry has earned for itself a bad reputation. So the rule of the Beis Din of America is we don't allow towing to represent parties in Beis Din. We allow and encourage people to bring attorneys, but not towing. The exception is if both parties agree to allow towing, and anyone who has a towing also has a lawyer present. We figure that'll keep them honest maybe, but we don't allow towing. So getting back to the Zabla discussion, we don't allow toanim to be borurim, meaning when you are choosing a dayan to act as your representative on the panel, we don't allow you to choose a towing as your representative. And the reason for that is because toanim are trained and that they're in the business of representing clients' interests, and we don't want it to be a game of one pit bull dayan representing a client's interest and another pit bull dayan, and then a third is really just the one neutral, and it leads to kind of a breakdown of the neutrality of the process. So we don't allow toanim to be borum, don't allow toanim to be dayan. So that's one rule that we have. The other preference that we have, but that often kind of doesn't happen when it comes to zablas that take place out there, is that ideally, dayanim are not supposed to have ex parte communication, not just ideally, dayanim are not supposed to have ex parte communications with parties, right? The whole integrity of the process and the whole neutrality of the process rests on the idea that these are three dayanim. They're insulated from any kind of side conversations with parties, and their only way to learn facts about the case is in an open court where everyone's there and everyone's present and has the ability to hear the arguments of the other side and has the ability to rebut the arguments of the other side. That's the only way it could work in a fair way. If there are side conversations between one party and any of the dayanim, that's a breakdown of the process. This is a pasuk in the Torah. The Torah says, Shamoa bein acheichem. The Halacha says very clearly you can't have ex parte communication with a litigant. When it comes to zablaz, the minhag in New York, so to speak, or the minhag in America, is that all goes out the window. The Aruch HaShulchan already, writing back in Europe, 150 years ago, writes that the minhag when it comes to zablaz, and everyone understands it, and everyone agrees to this process, is that you are allowed to have ex parte communications with the party that chose you, and that's just the way zablaz work. That's the way the Aruch HaShulchan describes it. At the time of the Aruch HaShulchan, perhaps they were on a higher level and they were able to kind of maintain a good neutral system even with the breakdown of that rule. Nowadays, I don't think we do as good a job doing that, and unfortunately, that's the situation. I'm sitting on a zabla right now, where, again, I view zabla as kind of second best, and if you can avoid it at all costs, you should avoid it at all costs, and have a case heard by a reputable Beis Din that has rules and procedures and that ensures there's no ex parte communication and that the values of that Beis Din can inform the process. When that's not possible, so zablas unfortunately have to happen. I'm sitting on a zabla now where the rules of the game, by everyone's agreement, is that there's ex parte communication. And it's a whole different kind of process. It's strange.
I've been party to that. So that is precisely why it's so distasteful. Is that there's this negotiation as to the Tainim switching in as Dayanim. Like that part of this process is like maybe I will just have this Tain and then we'll negotiate to have another Tain be another Dayan, and everybody's talking to each other how they're going to leverage the third part. It's unbelievable.
Yeah. There are no rules, so there's all sorts of undisclosed conflicts of interest. Like when you don't have a Beis Din that has rules and procedures and regularity and structure, you don't know what to expect. You don't know what kind of
unfortunately, and they shout, and the louder they shout, the more.
Right.
As you pointed out, the more the clients will be getting. And unfortunately, I've seen this. I've seen the shouting. I've seen horrific things said to Rabbanim in the name of Torah, in the name of Torah. It's a very, very scary. So I think sometimes when we think about Beis Din, just to speak into everybody's, and we hear distasteful things about Beis Din, a lot of times we're hearing the off-track Beis Din.
Right.
We're often hearing about what has happened when it didn't go through the classic Beis Din process, and therefore it turns into this unfortunate circus in many cases because all basic laws of communication have sort of been lost in that process.
Yeah, I sat a few years ago in a zabla in a divorce case, and the divorce case involved this young couple. They didn't have a lot of money, and
so what was the issue?
So that's exactly the question. What was the issue? What was the issue is exactly. I don't think there were no kids even. There was literally nothing to fight about. They owned a house together, and anyone in this room could have easily resolved the case, because what's the answer? You sell the house, you split the proceeds, and you move on with your life. And what happened was these young people were a little naive, and they were represented by, they realized they had a lawyer up and towing up, and the towing and lawyers saw that there was money here, and it was just entirely predatory. It was so inappropriate. I was sitting as one of the three dayanim on this zabla, and I was kind of begging my co-dayanim to let's just end this. Why is this happening? And instead, they were kind of okay with this going on. Each side had toanim that were okay with this going on, and they basically just filibustered until they drained the client's money. And it was a surreal experience. I felt like I was the only rational person in the room, kind of yelling at everyone, why aren't we just settling this? Sell the house and split it. And it was really an unfortunate situation where two young people got taken advantage of by a system that was just not designed at all to protect their interests and to watch out for them. So the zablas, you have to be careful with these zablas.
It's just important to distinguish between a reputable Beis Din and then unfortunately the side things that occur and the complexities of that. Let's go back to the Seruv. Let's say a person is in contempt. They say, I'm not interested, go fly a kite, I'm going to secular court, I'm just ignoring this altogether. So in that case, what does the Seruv actually mean today in today's Jewish community?
So I would throw it back to the rabbi, meaning the power of a Seruv really depends on the willingness of the community to stand behind the Seruv. I would say, as an observation, that Seruvin that we issue for Gittin, meaning against a recalcitrant husband often, who's refusing to give a get, that captures the attention of the community very often, especially in a modern Orthodox community, a community that kind of is sensitive to issues of aguna and really gets charged up by that specific thing, will take a seruv against a recalcitrant husband very, very seriously, to their credit. I would say, to some extent in a community like this, but even more so in a place like Bergen County, where there's just, a very cohesive and united rabbinate that all take it very seriously. It's hard to be a ma'agein in Bergen County, meaning it's hard to be the husband withholding the get in Bergen County because you really don't get there's no shtibel that you could run to and take refuge in. The rabbis and the community, to their credit, really take it seriously. I think that's true in the 5 towns also. The rabbis and the community take it seriously. I would say a seruv for someone who's refusing to come to Beis Din on a commercial matter, they're in a Hasidic community. That's like the worst thing in the world to be in our coast, to be in the secular courts, and they'll really gang up on you and really make you feel unwelcome. I think less so, that's true, less so in the modern Orthodox community, where there's just not quite that sensitivity to the Isser HaKos, to the prohibition against litigating in secular court, and the seruv is sometimes less effective. It's really up to the community's leadership, to the rabbanim in a community, to figure out exactly what should happen to someone who has a seruv against them and the degree of ostracism they should experience, right?
So actually speaking on that topic, so about the secular court, so what happens if a person says, look, I'm not interested in this Beis Din process, I just want to go to court, like where does that exist as an option? So
we should have started with that, because the backdrop to all of this is that there is a prohibition against litigating in secular court. Pasuk says, "Ve'ila mishpatim asher tasim lifneihem," the introduction to all of the civil law in the Torah, Parshas Mishpatim. It says that these are the rules that you should place before them, and Rashi quotes the Gemara in Gittin that that you should resort to Jewish courts and not to secular courts. And the reason that the Gemara gives, and the reason Rashi cites for that, is someone who resorts to the secular courts is kivuherim yado b'toraso shel Moshe Rabbeinu. It's as if you're raising your hand against the Torah, which is another way of saying we, as a Jewish community, we as Jews, should feel confident that we have a robust and sophisticated system of civil law. It's true that the United States also has a robust and sophisticated system of secular law, but the Torah understands that if you turn your back on Batei Din and say that the place for me to resolve my monetary disputes and the place that I know that I really can get a fair shake is the secular court system in Nassau County or wherever it is, that is a slap in the face to the Torah of Moshe Rabbeinu. It's as if you're saying that I trust that system more than I trust our own internal system. And that forms the basis for a prohibition that many Rishonim view as a Torah prohibition of litigating in secular court. That's why Batei Din exists. That's why we're here to resolve monetary laws. One of the kind of values that informs my decision to go into this line of work, and that stands behind our hard work in trying to ensure that there's a fair Beis Din, and a Beis Din is sophisticated, and that has lawyers involved, and that has published rules and procedures where the proceedings are recorded, and where there's just something very professional and structured about the way that we do this, is the fact that it's not fair to expect a community to abide by a Torah prohibition or a Torah rule where it means that they have to abandon legitimate claims or put themselves at the mercy of a Beis Din that's not sophisticated in the name of following Torah law. Torah law is there, but it's important to have communal institutions that support the abiding by Torah law. That's why we build mikvahs that are comfortable and that are appealing and that are beautiful, because we want people to have an option of following Torah law in a way that they don't have to sacrifice their personal comfort, to a great degree. We want kosher food to be readily available, because it shouldn't be a nisayon every time you go to the supermarket. Should I keep kosher or should I not keep kosher? And the same is true for Batei Din. It shouldn't be that the Torah says you have to go to Beis Din, But you have to now agonize over whether that Torah prohibition means that I have to abandon legitimate claims or I have to be put at the mercy of someone winning a judgment against me that he doesn't deserve. It's important for communities to establish batei din that are legitimate and that offer a predictable process and that's fair, so that people can feel confident. I'm following Jewish law, I'm following Torah law, but I'm doing so because I know that there are communal institutions that back me up and that make that a legitimate and reasonable option. That I think, when I show up to work every day, that's a value and a goal that I think is important and that we should all
That's
strive
right, it's a
for.
very important thing. So but let me ask you, being as the Beis system is not a legally recognized structure in the United States court of law, so what is the teeth? So let's say people go through this process, or how are they guaranteed that the decision is going to be upheld in law?
So it is, meaning part of the byproduct of us creating a professional system where we have rules and that we abide by the rules is that in the United States there's something, and not just in the United States, but in every Western country, there's an institution or a process called arbitration. You don't have to have the courts decide disputes. You can agree by contract to delegate the decision-making authority to an individual or a body, an arbitrator. And so, alternative dispute resolution is a popular way of resolving disputes nowadays. There's the American Arbitration Association, JAMS. There are professional secular arbitration bodies that handle disputes, and the same thing. And a Beis Din functions in the same way as the American Arbitration Association functions. Two parties to a dispute sign a binding arbitration agreement at the beginning of the process, and because they've signed that contract, secular courts will accept and uphold the decision of the Beis Din, as long as the Beis Din isn't corrupt, as long as we're not cheating, as long as it's a fair process, and that's that people can bank on that. They sign a binding arbitration agreement, and that means that our decisions are enforceable in court. It means that at the end of the day, we issue an arbitration award in writing. It contains reasoning. It doesn't have to, under law, contain reasoning, but ours do. We explain the basis, we explain the secular law, the halacha, all the relevant considerations, the facts of the case. It's very clear from the decision that we understood the case and we understood all the issues. And then you can take that, go to court to confirm the award. The court will then issue a judgment that backs up the award, and that's an enforceable judgment just like any court judgment is.
Thank you for explaining that process. I guess with some of the hesitations I hear from people, and I just wondered if you could address this, is two things. One is, let's say when it comes to custody cases, if it's not the court of law, so what's the protocol for custody? And the other one is the appeal process. Let's say a person feels they're badly done by, so in the court of law, there's a way to appeal the case. But in the Beis Din, is there such a process? And so those are two questions that people oftentimes have. Before saying, I'm going to submit my life by signing this arbitration agreement to which they feel scared of.
Yeah, that's understandable. So the answer is, first of all, I should point out, when it comes to custody issues, actually as a matter of New York law, our decisions are not enforceable. So as opposed to financial issues, and even within a divorce case, child support issues and the financial aspects of divorce, that's all enforceable by virtue of the fact that they signed the binding arbitration agreement. But custody issues, figuring out who should have custody of the children, who should have decision-making authority for educational decisions, for medical decisions, how should the time-sharing work between two parties, that's all something that under New York law is not delegable to a Beis Din, and the courts retain jurisdiction over those cases. That's different than in New Jersey, for example, where you could actually arbitrate custody issues. But in New York, you can't arbitrate custody issues, or I should say, the decision of the Beis Din is not enforceable in court. However, I would say that in virtually every case where we decide custody issues, the case does not end up in litigation in court, because our process is a good process that results in finality, even if not legal finality, by virtue of the authority of the Beis Din, practical finality to the case. Because, let me talk a little bit about our process when it comes to custody cases and why it's a good process and kind of how it's structured. So we always ensure that when there's a custody case in play, there's always a mental health professional, either as a member of the panel, and I just saw him at Chakras this morning. Dr. Norman Blumenthal is often that person, Dr. David Pelkovitz, has in the past been that person as a member of the panel or as a kind of fourth person sitting on next to the panel as the consultant to the panel, but who's there for all the hearings relating to custody. And that means that we end up with decisions, I think, or with a process that's even better than the courts, because the courts rely on professional testimony, but ultimately the judge deciding the case is not a person who's a mental health professional. He doesn't know necessarily the best interests of the children. And so our process, by virtue of the fact that there's a mental health professional in the room advising the panel, or on the panel, I think adds a lot to our process for deciding custody. That's number one. Number two is the standard that we utilize for deciding custody issues is exactly the same standard as the standard utilized by the courts, which is the best interest of the children. That's how we're deciding the case. It's not based on anything other than the best interests of the children. And so that combination of a mental health professional involved, the standard best interest of the children, results in decisions that are going to look very similar to what you'd see in the secular courts, practically speaking, but with an added benefit of cultural familiarity, cultural competence. You have dayanim who understand yontif schedules, who understand the differences between schools and yeshivas, and when the parties are fighting over which yeshiva, they have that cultural competence that a secular court judge doesn't have. Also, the culture of the courtroom is a lot different. When you go to court, it's a very sterile environment. The lawyers are doing all the speaking. There's huge amounts of motion practice. It takes place over a long period of time, and that's not good for the children because they get caught in the middle of often a very acrimonious divorce process that goes on for a year or two. That's absolutely terrible. At the Beis Din of America, these processes usually take a few months. We just had a case that resolved itself within 3 months. We had another case that also maybe 2 months. It's a very swift and thorough, but still a much more efficient process. The other thing about the culture of the atmosphere in which this takes place is when parties come to the Beis Din, and like I said, there's a mental health professional in the room, often it's Dr. Blumenthal. What happens is often something that looks more like a therapy session than a court process. Because Dr. Blumenthal kind of mixes in, or whoever the mental health professional is, kind of mixes in with the proceedings advice. And it ends up often what started as an arbitration where it's the dayanim that are going to be the decision makers, it devolves into more of a mediation where the parties are kind of throwing out ideas and talking about acceptable schedules for visitation and what works best for the kids. And Dr. Blumenthal will nudge them this way or that way and will kind of throw out words of wisdom. And you see often these parents who are going through a very difficult time, they're scared about what's going to be the situation with their children. Their children are going to go through a tumultuous situation. They eat up Dr. Blumenthal's words. They take his advice, and you end up with kind of a very dynamic conversation in the room that results often, very often, in a settlement. I'm thinking the last 2 cases we heard just in the last few months, what started as what looked like it would be an acrimonious custody battle, ended up with a settlement between the parties right there and then in the courtroom because we were able to have a dynamic conversation. That doesn't happen as readily in court. Court is a much more formalized process and much more adversarial just by its nature. And I think personally that's the biggest advertisement, the biggest reason why, set aside the Isser HaKos, the prohibition of litigating in court, set aside the cost and the fact that the process is much more efficient in Beis Din, the fact that the Beis Din is kind of a culturally competent, sensitive group of dayanim and mental health professionals who are there to have a conversation that leads to a resolution that's in the best interest of the children, that works best for both parties. That's the best reason for divorce cases to be handled in the Beis Din rather than in court. It's important to realize, though, in all this, you have to choose your Beis Din wisely. Meaning, I speak here about the process of the Beis Din of America, and I feel very, very confident that it's the place to do this and where you could really get a good streamlined outcome. It's caveat emptor. It's buyer beware in terms of which Beis Din you're going to. You have to know that you're going to a Beis Din that has these features.
And just to the appeals question, like
The appeal question,
So
yeah.
let's say people feel that they were badly done by. Is there a process of appeal?
So the Beis in America is another unique feature of the Beis in America. We have an internal appeal process. So within 20 days after we issue an award, you could, by written submission, appeal our decision to the Av Beis Din. If you think that we've made, in the rules and procedures, it's phrased as a mistake of Jewish law. If you think we've got it wrong, you could appeal to the Av Beis Din. The Av Beis Din is Rabbi Mordechai Willig. He will often delegate it to another dayan at the Beis Din, whether it's Rabbi Yonah Rees or someone else, or he'll handle it himself. And then there's a process whereby written submissions back and forth over the next, the other side has 10 days to respond, the other side has 10 days to respond, and I think there's one more response, whatever it is, it's in the rules and procedures. You can kind of argue that we got it wrong, and the appellate dayan will review it. And often enough, there's some, some change that happens, or it gets remanded back to the panel with, clarifying instructions. I would say the vast majority of situations, the initial decision of the panel is upheld, but there are times where it will get modified or revisited based on some argument that comes to light. It's a good way for us to kind of double check our own work before it goes to the courts, because we rely on the courts to rubber stamp our decisions. So it's nice to have a kind of a second look internally to make sure we got it right.
There are so many more questions that I would like to ask, and that time is really coming to a close. I just wanted to perhaps on a personal level is, you deal with people all day long, and sometimes the worst of people comes out when it comes to basing, because what are some of the lessons, what are some of the, it's something you've learned from people which gives you hope through this process?
Well, I would say this, I think arbitration, and even more so mediation, over the years I've learned, is such a useful process. Meaning people get into disputes, people get into fights, and often it can be very, very adversarial, very acrimonious, and people really, their worst sides are shown. And when you have an organized process with, people with experience who are there to try to work through problems, it actually works. I think 15, 16 years ago when I started this, I was skeptical that if you have a real bona fide dispute, you get people in a room and you could somehow work things out. But the process, when done well, and I'm speaking about mediation more than arbitration, even, although arbitration also has this element, there are ways to kind of get people to calm down, to focus on the issues, to focus on the fact that their own interests are not served well if they continue a fight, and there's room for compromise, and there are ways to kind of maximize the interest of the parties by talking through and coming up with creative solutions to problems. The answer to your question is, notwithstanding the propensity that people might have to fight and to get into disputes, I do think that having a professional and well-run institution in Jewish life where dispute resolution can really, really serve the people, and has the ability and the promise of bringing resolution to disputes in a way that works.
Thank you very much. This has been very refreshing, and I'm going to advise people to you can subscribe as well to the Beis in America has many court cases, past cases, which they publish and anonymized, just to get a sense of some of what the complexity of the types of cases that are dealt with. And it's refreshing. It's refreshing to appreciate this, and thank you, Rabbi Weissmann, for your time, and first for the Jewish community, your time for the Jewish community, and also sharing us a little bit of a window into this incredible institution.
Thank you.